let me start by putting it in general context. The anti-SLAPP legislation, and SLAPP stands for Strategic Litigation Against Public Participation. We'll get into that more, but basically the reason for it is that what was happening in the past, particularly with environmental organizations, is that they were saying bad things about forest companies, and those forest companies were then suing them, not because they thought they could win necessarily, but because they knew that they were underfunded NGOs and they could drive them into bankruptcy or drive them into being afraid to ever do it again. So this legislation, it creates a mechanism for a defendant, that's you guys, in a lawsuit to bring a motion to dismiss the proceedings at a very early stage if it arises from an expression made by you people that relates to a matter of public interest. Now, for the most part, what you publish is going to be in the public interest. And I'll get into this later, but it's not a very high, our courts say that they're not going to get involved in telling people what's in the public interest and what isn't, unless it's clearly not in the public interest. But I mean, if you're writing about something that could be of interest to a group of people that has to do with anything to do with public policy or public morality or commenting on the way the government's run or any large organization is run, that's going to be clearly in the public interest. Because the reason for this legislation then is to allow the defendant to go before the court and say, look, we don't want to get involved in a long court case. We want you, the court, to look at this legislation and decide whether you can dismiss the application. And I'll get into this further, but there are, one of the big issues in lawsuits is not the damages necessarily, but often the costs. And this legislation also provides for a very, very generous cost regime for the defendants, for you people, when you win one of these lawsuits. And it reduces the costs that could be awarded against you if you lose this kind of SLAPP motion. So what happens, just by way of general overview, is that you get served with a notice of libel and then a statement of claim. At that point, before you even file a defense, if you want to, you can bring a SLAPP suit application. Now, there may be strategic reasons for filing the defense first, and there may even be strategic reasons for exchanging documents with the other side first, which we have done in one huge case dealing with St. Michael's Hospital. And I'll explain why in a moment. But that's the general idea, is having an opportunity to get rid of these expensive lawsuits without being punished by going through each of these expensive, very expensive processes, like the examinations for discovery, like getting all the documents ready, like getting all of your witnesses ready, like dealing with motions to complain. The other side can complain that your statement of defense wasn't sufficient, and on it goes. And all of this mounts your costs. And whatever your I know that many of you may have insurers, but the insurance issue there also means that you may not have to pay as much on your deductible, whatever that may be. So you've got a real advantage through this legislation if the facts work for you. The lawsuit is basically going to try and help the defendant come up with a way of dealing with the lawsuit against them, loss against them immediately. As it says here, what the lawsuit does is it allows you to use the court system to limit the effectiveness of the opposing party's speech or conduct. And SLAPP suits can intimidate opponents. I mean, the minute you start to think about publishing something about somebody, and if the other side is well-heeled and they're saying, well, if you say that, we're going to sue you. Quite often, that causes particularly smaller publishers, but I can tell you sometimes larger publishers too, to back right off and say, okay, we're not going to go there. It's not worth the candle. And That, of course, is not a good situation to be in, and I'm not saying this is absolutely going to solve that, but it's going to reduce this, because you'll be able to sit back and say, well, wait a minute, this is basically what you're talking about, is bringing a lawsuit to prevent discussion of something that should be in the public realm. And as it says at the bottom here, expressions that it relates to matters of public interest, and I'm going to get to that in a moment. The reason that it was introduced is that the Attorney General of Ontario decided that there should be a consultation because of the complaints that people were getting, mainly from NGOs at this point, about what this was doing to their ability to express themselves freely. The majority of the submissions supported the introduction against SLAPPs, and in BC, they did have an act. It got repealed, and with the current changing government, I've got to say I'm hopeful that this Ontario legislation doesn't get repealed. It's not legislation. It is, if you're going to divide things between the more conservative and the more liberal approach to freedom of expression, this is way more over on the more liberal side. So I'll let you draw your conclusions about where the current government, or the government to be, will be, but we're hoping that they will not interfere with this. So the purpose is basically, you can boil it all down, you've got them there, but it's to encourage people to be able to come forward and not to be intimidated, and to discourage the use of litigation, in particular, the use of litigation to cower people, make people cower and move on. The legislation speaks of these first four. The fifth one here comes out of the cases that have come forward. The rationale behind the provisions to encourage resort to the legislation in order to weed out claims designed to suppress public participation and debate. So there's no more classic example of that than someone deciding that they're going to sue a book publisher for publishing a book in a certain area, because that'll teach you not to do it again. That'll teach you not to accept manuscripts from somebody that's going to be critical of, let's say, a big forest company or a big construction company, because it almost drove you bankrupt last time, so you're not going to do it again. So one of the things that the courts have recognized is that it's designed, this legislation, to prevent that kind of unfair use of the court system. So the legislation talks about the matter has to arise from expression. Well, if you're a book publisher, it almost necessarily is going to arise from expression. And expression, of course, means any communication, regardless of whether it's verbal or nonverbal, whether it is made publicly or privately, and whether or not it is directed at a person or an entity. So that all looks pretty obvious, but when you get right down into it, verbally or non-verbally, you mean it doesn't have to be written, and it doesn't. It could be pictures. It could be that you want to publish pictures of, I'm going to go on about forest companies, but you want to, the clear cutting that was done. And they're going to say, no, that's, you know, you're publishing those pictures, but what about all these pictures over here that show all the trees we've planted? And, you know, that you get into that kind of them attempting to edit you and trying to intimidate you into publishing something that perhaps you don't really want to publish. So clearly, any expression, even talking on the phone. So if you had a graphic novel, for example, it could be covered. Unflattering pictures. Quite often we have situations where someone will say, well, the picture that accompanied that story was of my client, and it was not a very pleasant picture. The Globe and Mail did a series a little while ago, about a week ago, about an individual whose they claimed that had way too much influence over the governments, a guy named Spiros. And the picture that they used wasn't terribly flattering. I didn't think it was terribly bad, but the worst one we had was they couldn't get a picture of the target, and so they got a picture of him Saturday morning in a tracksuit with a hood. This is a middle-class guy, right? He wasn't some kind of he wasn't some kind of bad actor except in this one area. And he was opening his garage door, and they were out on the street, and they got a picture of him, and he was looking around shocked, and the picture made him look like a hoodlum. It made him look like he was breaking into the garage, actually. And the court didn't think very highly of that. So pictures matter, but in terms of the kind of thing that you can claim you have the right to express, pictures are part of it. Anything that falls generally under the rubric of expression is going to work. So what does the legislation say? On a motion by a person against whom a proceeding is brought, so in other words, you guys are getting sued, and the judge shall, let's forget about subsection 4 for a second, dismiss the proceeding if the person satisfies the judge that the proceeding arises from an expression made by the person that relates to a matter of public interest. So, leaving aside subsection 4, and we're going to talk about that for sure, but basically what it means is that you come before a judge and you say, this is on a public interest matter. Judge, I want you to dismiss it. And that can happen, as I said, very early on in the process. And it's mandatory. The judge shall, which is unusual, because very often in legislation, the judge may, or if reasonable, none of that. This is absolutely mandatory. Shall dismiss unless you meet the criteria under section 137, 1.4. Now there's a few cases on public interest, and I'm not going to go into the cases themselves, but in that first one, allegedly defamatory comments about acts or omissions of a mayor and a municipal council. Okay, so now you're talking about politics. Obviously, that's going to be in the public interest. That was said to be an expression of public interest. The Niagara Peninsula case, comments about the governments of a conservation authority, obviously in the public interest. In Rivian Newman, social media postings about the character and suitability for an election of a candidate for election to Parliament, obviously in the public interest. This was our case that we were acting for Chorus on. A local radio station reported on comments made by a candidate about her opponent during an election campaign, referring to his behavior as bullying, and hyperlinking in the online article was to an old news story about a criminal conviction. And the other side in that case just said, we concede the public interest aspect of it. But we're not saying that you've made out the case under the exception. And the Armstrong case was kind of interesting because it related to and I'm going to give you a little bit of the history because it's going to fit in later, but this guy Armstrong was running to become a municipal councillor, and his opponent found out that about 10 years ago, he had been convicted for a criminal assault. And it wasn't a big deal, but there it was. She released that in the midst of the campaign. And Chorus, being the Chorus local radio station, being talk radio, got on there, and their major issue was, is this fair that she did that? Should she have done that? It wasn't like, should we elect Armstrong? It was like, is this fair, et cetera. Now, one of her allegations against Armstrong was that he was a bully. And there had been stories, other reports of him trying to bully people. So anyway, Armstrong wins the election anyway. So now you get down to an issue of, like, what were his real damages? Why was this so serious? Even after having won the election, he brings this lawsuit against her and against the radio station. And we were just on for the radio station. And basically, we were able to say, look, this clearly isn't the public interest, so the other side conceded that. And I'm going to get into the exceptions in a moment. I'm going to give you a couple of examples of where it wasn't in the public interest. This in the Veneruzzo's case, after he pled guilty to an offense of dangerous driving, causing death to a plaintiff's family member, he, who was a police officer, made online posts on his Facebook account in which he implied that the deceased had contributed to the accident. And he criticized the family in personal ways, including accusing them of being intoxicated and belligerent towards police on the night of her funeral. The posts were negative comments about private individuals, not public officials. At their highest, the posts were about events that interested the public, not events which were in the public interest. So let's keep that. That is something that is an important expression. Something can be of interest to the public, but not in the public interest. For example, the length of some actors' dress on the red carpet may be incredibly interest to some people, but it's not in the public. It's not being reported in the public interest. A story about somebody who is not known, just talking about their night going out drinking in Toronto, might be very interesting, might be very amusing, but it's not likely to be in the public interest. Now, if you get into, like, look at the effect of the liquor laws and look at the effect of the new marijuana legislation, et cetera, then that could turn it into a story of public interest. But there's a lot of what is written that's not in the public interest, but is of much interest to the public. That's why you're able to sell your books. But as I say, I would expect that the majority of what you people are publishing is public interest material. So now we're getting down to those exceptions. And they are unusual for a number of reasons. The first is, the judge shall not dismiss a proceeding if the responding party satisfies the judge. If the responding party, that's the person who is suing you, because you've brought this motion to dismiss it, so they're responding to that motion. So the responding party has to satisfy the judge. In other words, the responding party has to prove to the judge that there are grounds to believe that their case has substantial merit, and this is the big one, that you, the publisher, have no valid defense in the proceedings. Now that is incredibly hard to do, particularly at an early stage. I mean, if you simply plead, look, we did our very best to get it all right, and therefore this is going to be, one of our defenses is responsible communication, where, you know, the courts we established in the Supreme Court of Canada a few years ago, that if you can demonstrate that you jump through all the hoops that you should jump through in order to get it right, even if in the end you get it wrong, you still get a defense. So you could simply go forward and say, our reporter or our author did these things, they checked the facts these different ways, that should be sufficient, and the judge will look at that and determine whether or not, in his or her view, the responding party has shown that you have no valid defense. And the reason that that is so important, and I want to emphasize, is that it is the person who is suing you that has to say you don't have a valid defense. So you don't have to say a lot, they have to say everything. They have to point out why you have, and this is one of the reasons that I think this legislation, frankly, may be too good to be true. Because this is very unusual in legislation to put the party who is not advancing an argument to the test of proving that the other side's argument is not valid. Once you get through those, the harm likely to be or to have been suffered by the responding party as a result of the moving party's expression is sufficiently serious that the public interest in permitting the proceeding to continue outweighs the public interest in protecting that expression. So what does that mean? It means The judge then balances it and says, okay, what harm did they likely suffer? Don't forget, at this point, the judge doesn't know what harm was actually suffered. All the judge has is whatever material's been filed. So that may be just the statement of claim, maybe just the statement of defense, maybe an affidavit in support of the motion to say what it is that, what the harm is. So to go back to my chorus case, when we were in the Court of Appeal, the judges said, well, I don't understand what the harm is. He was reelected. So where's the big harm? And I'm afraid that they're going to decide it on that basis. I mean, we still win, but I'd rather win on another more universal basis where they're interpreting the legislation in a way that will be helpful in future cases. Because for the most part, having a situation where the judge is going to say, he didn't suffer any harm, it's kind of rare that you can actually get that severe a judgment. Now, that was what the judge said from the bench. We'll see what they're actually going to write. And let me put that chorus case in a bit of context. We lost at first instance. We got a really, with all due respect, a really hopeless judge who, in the legislation, it was the first case that the courts had heard under this legislation. And I think the judge looked at it and he had kind of the same reaction that I had. They can't really have meant it this way. Anyway, he made his decision. We are going to, I'm very certain that we're going to win in the Court of Appeal, either on that or another ground. But at the same time, there were 5 other cases that were under appeal to the Court of Appeal. Decisions that had been, cases that had been heard by the Superior Court after ours. And what the court sometimes does, if they're dealing with particularly a piece of new legislation, is they'll lump all the cases together and they'll hear them all separately, but one after the other. So last June, almost a year ago, there were 6 cases heard over 3 days in the Court of Appeal, and our chorus case is one of them. And normally, the Court of Appeal comes out with its judgments at the worst within 6 months. We're almost a year away. It makes us all wonder, what's taking the court so long? Is the court having trouble with the legislation? Are they concerned about this aspect of it? Although one of the parties before the court brought a constitutional challenge saying this legislation isn't constitutional because it's too favorable to the defendant, and that was dismissed right from the bench. So it's not a constitutional issue. I don't know, frankly, what it is that's stopping it, but that's where we are. So the law is in a little bit of flux here. The judges that heard the case generally are very deferential to the word of the legislature. You know, you hear about some judges who are creative and don't adhere strictly sometimes to the legislation and try and mold the legislation to be more liberal or more conservative than the wording actually suggests. The judges that we had were all black letter law judges. The type who would look at this and say, well, that's what the legislature said, that's what we got to do. So why are we waiting so long? I don't know. So under the legislation, the plaintiff has to prove that it is a meritorious case and that the defendant doesn't have a valid defense. So of course, we're lawyers, right? So we have to say, okay, well, what do you mean by have to prove? On what basis? Early cases suggested that the standard of proof was that it wasn't frivolous or fleeting. Must prove, you can just plug those words in here, must prove that the case was not frivolous or fleeting. And then they got into, must prove that there are reasonable grounds to believe based on credible and compelling evidence. And this is what we suggested to the court, was because the court asked me, said, well, what do you think the test should be? So that's where we said it should come in. And then Later, some cases suggested that the standard should be of balance of probabilities or something approaching that standard. Now, the balance of probabilities is the usual civil standard. You know, the criminal is beyond a reasonable doubt. So in a criminal case, you have to prove with great deal of certainty, the Crown has to prove with a great deal of certainty that the person is guilty. So we're talking about, if you want to talk in terms of percentages, you're probably up around 90%. Balance of probabilities, 51%. So a judge can say, you know what, I believe you over you. You're both probably telling the truth, but I just think I believe you a little bit more. That's the balance of probabilities. So one of the big issues in all of this is how far does the plaintiff have to go? Does he have to prove it? Does he or she have to prove it on a balance of probabilities? So when we get down to this, this is the Bonfield construction case, and we were acting for the Globe and Mail on this. And it was a huge case involving several articles by the Globe and Mail about Bonfield construction and their construction of the new wing of St. Michael's Hospital. And there were some raised by the Globe and Mail, some big questions about how it all was handled. And the main thrust of the article was not should Bonfield have gotten the contract, but some could interpret it that way. Basically, there was concerns about the oversight that the government had of the contract and why certain things went the way they went. So what we decided to do in that case was to exchange documents with the other side, because what we wanted to do is to establish, with documentary evidence, the huge amount of research that was done by the Globe and Mail. This was one of those stories that took months and months and months of several crack reporters to be chasing down leads all over the place and getting things confirmed. So that, you know, did so-and-so really say that? Yes, he did. Did anybody else hear that? Oh yeah, I think Joe Blow did. Okay, so we got to go and talk to Joe Blow, and on to make sure that they really had it right. Because that's going to be one of the things that the court's going to say, okay, Globe and Mail, what's your defense? And we want to be able to say, it's the responsible communication defense. That is that we did everything you could reasonably do to get the story right. So we're not saying we got it right in court. I mean, the Globe is saying it got it right, but in court, we don't have to go that far. We're saying we did everything we could do to get it right. Now, one of the reasons that approach became necessary, and there was a case some time ago of a minister of defense was over in Lahr, Germany, and he was allegedly cavorting in some bar and went into the back of the bar where there were some prostitutes, et cetera, et cetera. And the story was run. I think it was the Ottawa Citizen. And we wanted to get the cabinet documents that reported on all that he had done. And the federal government said, no, you got no right to cabinet documents. There's absolute privilege on those documents. So you don't get them. So they were depriving us of being able to prove that what we said was right. And eventually, the case got settled because it was political. It went away. But it always left me thinking, you know, there is a situation where the other side can just rope-a-dope and just can say, I'm not telling you anything. I know you've got it wrong. I'm not telling you anything. And so you do all your research, you still get it wrong, and then they could, before this legislation, they could successfully sue you. I mean, before the responsible communication defense, they could successfully sue you. Because back in the old days, if you got it wrong, you got it wrong. That's all there is to it. I don't care how much checking you did to determine whether Jim Turk was on the take at Ryerson. He's not, but you know. I don't care how much research you did. Jim could say, you got it wrong. And we could say, yeah, but we talked to the director of finance, we talked to people in the administration, et cetera, et cetera. They all told us the same thing. They provided us with documents, but you know what? It was all wrong. It was a different Jim Turk, whatever, right? We would have no defense without the responsible communication defense. So we wanted in Bonfield to be able to demonstrate that we had done all this, so we wanted to give them all of our documents. And that was a horrific job because there were numerous confidential informants. And so these reporters had to spend, they will say months, I will say weeks, in our offices going through all of the documents, and there were thousands of them, emails back and forth, making sure that there was nothing in any of those documents that would tend to identify a confidential source. And in the end, we won the motion, and our costs rather, on that motion, were slightly over $500,000. So you can see the kind of thing that they're trying to prevent. I mean, if this case goes to trial, it's going to be that's going to be nothing. And so if you're the Globe and Mail and you've got a huge insurer behind you, maybe you can afford that. But even, you know, our argument to the judge is, with the way the industry is going these days, nobody's got that kind of money. So it's always intimidating when one of these big companies comes and sues. And so we get very concerned about the fact that a story is being done that could generate a huge lawsuit. And that's why they get the lawyers involved early on. So what steps can we take to minimize, A, the likelihood that we'll get sued? And sometimes they say, you know what, we know we're going to get sued. But now how do we protect ourselves? And we spent a lot of time with the Globe reporters suggesting, go and check this out. And they're going, really? Yeah, the guy won't talk to us. At least put it on the record that you tried to talk to him, so that that can be part of responsible communication. Make sure that you tape, and this is good for you people with your dealing with your authors. If they're phoning up a source and they say, look, I'm going to say this about you in this book. I want to know what your comments are, or I've heard this about you and I'm writing a book about you. You want to make sure that you can prove that you told the person what you were going to say, so that when the time comes, you can say, I did everything I could do. I asked him that. And you don't want to be in a situation where the person says, oh yeah, they phoned up and said they were writing a book about me, and I just said, well, I'm not interested in helping you out, click. That's a lot different than, I'm writing a book about you, and I'm going to say that you caused this dam not to be built, and therefore a whole bunch of native land was flooded or whatever. I mean, you've got to put the actual allegation to the person, and you've got to be able to prove that. So there's two ways that and to be able to prove it, it's got to be in some reproducible form. So if you're going to do it in a phone call, tape the phone call. If you're going to, and if you do it in an email, you keep the email. But you've got to have some proof that you actually put the sting of the allegation to the target. And then that person cannot come along and say, I didn't know what she was talking about. Whereas if you just say, I'm writing a book about you, well, you didn't tell me you were going to write that about me. And I would have got back to you on that. So it's not usual that you get into the situation where you have to do what we did on Bonfield, but I wanted to tell you about that just to give you a sense of the expense that can be involved. Getting $500,000 in costs for a motion is pretty unusual. And as I said, the plaintiff has to prove sufficiently serious harm. Now, in most defamation cases, there's no debate that the plaintiff doesn't have to show actual harm in libel. So for example, there's two kinds of damages in libel. There are what we call actual damages and damages at large. So the actual damages are where someone, let me give you an example. Let's suppose you're standing at a bus stop and somebody drives by and says to the person beside you, you're a thief and a liar, and no one should ever do business with you, and drives off, right? So this person now wants to sue that person for what would essentially be slander or defamation. So the first kind of damage would be, look, you said that in front of a whole bunch of people at the bus stop. I was humiliated. It was horrible. I want damages. And the court will award damages for that kind of thing. But let's suppose that as a result of that, the guy gets fired. Somebody believes what was said or says, you know what, I'm not going to say whether you did it or not, but we just don't want an employee with that kind of smell around them. If that happens, and on top of that, the person is really rattled and ends up having to go to a psychiatrist, a shrink, and get therapy, et cetera, then you've got some damage that you can actually calculate. You've got real damage, the amount that they had to pay for the therapist, the fact that he lost a job or he lost a contract. Now, those kinds of damages are harder to prove, but they're the actual damages. And so when I say here, the plaintiff has to prove sufficiently serious harm, but doesn't have to prove, which would mean that just the insult itself wouldn't be enough. You'd almost have to show that there are actual damages, something that actually happened as a result. Like people stopped coming into the store or whatever. You'd have to show something more than my feelings were hurt. Not that my feelings were hurt isn't a very legitimate ground. They would have to prove that, they'd have to put affidavits forward and say that, nobody in the neighborhood will talk to him anymore, et cetera, that kind of thing. Whereas in libel, you wouldn't have had to do that. You would just get something back for it. What the court does, it weighs against the public interest in protecting expression, the chilling effect on speech, and then, of course, Section 2B of the Charter, where we have a right to freedom of expression. So what is it that has been said here that should limit you, the book publisher's, right to publish this expression of opinion? How serious is it? And then, also in balancing the harm is likely to have been suffered by the responding party as a result of the moving party's expression is sufficiently serious that the public interest in permitting the proceeding to continue outweighs the public interest in protecting that expression. So in our case, was the Globe's publication of what was going on at St. Michael's Hospital and all that, did that outweigh whatever harm it is that Bonfield can say that it suffered? So that would be the balance. And this is the one that in our Chorus case is the one that I think the judges may end up deciding on. As much as we'd like them to interpret the legislation the way we want to, and we went on and on and on and on in our factum about how it should be interpreted to the benefit, they might, in our case, they might ignore all that and say, well, what was the harm suffered by the guy? He got reelected. So how could that outweigh the public interest of Chorus having a radio program about whether or not it was dirty politics to be running the fact that he had a previous conviction? This is where it gets, again, quite interesting. Let's suppose that you win on this motion. So what are the cost consequences? The moving party, that's you, are entitled to costs on a full indemnity basis unless the judge determines that this is not appropriate in the circumstances. So what's full indemnity? Full indemnity means that you get somewhere in the neighborhood of 90% of your costs back. So if you paid a lawyer $100,000, you should be getting somewhere in the neighborhood of $90,000 of your costs back. Partial indemnity, which is, generally speaking, it's the other rate of costs, is probably in the neighborhood of 60 to 2/3. So if you take a regular motion to court and you win, you'll likely get 60% of your costs. So that means you're eating 40%. And in a big case, that's a lot of money to eat. On top of that, you've got to keep in mind that some of what you will allege were your costs, the court may say, no, I mean, you're talking about these meetings. I don't think that they were that important. And I know you had to pay your lawyer to come to those meetings, but we're not going to allow that. But everything that's allowed full indemnity, very unusual, on a motion. And that is to allow you, the little guy in all of this, some assurance that you're not going to be scared to bring a motion like this where it's going to end up costing you 40% in any event, even if you win. So that's if the proceeding, that's if you're successful. Now, and you can see this Platnick case was one of the 6 that was in front of the Court of Appeal. At the lower court level, there was $282,000. So it's big money in this stuff. And in our case with Bonfield, over $500,000. If the proceedings are not dismissed, in other words, you bring this motion and you lose, what happens? The person that you brought, the plaintiff, the person that's suing you, is not entitled to costs unless the judge determines that this is not appropriate in the circumstances. So the fallback position is that even if you lose, you don't pay any of the other side's costs. That's very unusual. And so that's a complete departure from the usual practice in civil cases that the winner of the proceedings of the motion is entitled to costs. And usually, and I could add the end of that, is entitled to costs on a partial indemnity basis. So usually the winner gets 60% to 66% of their costs. Here, if you win, you get full indemnity, 90%, and if you lose, you don't pay anything. Now, both of those are obviously in the discretion of the judge, because see, the judge determines. It's not like the shell that we dealt with early on, but this is very unusual and very, very good for you guys if you're bringing a motion. Now, when we get down to the damages aspect, where you can get damages if you can show that the party that's suing you was bringing an abusive claim. It's rare, but it has happened. There are 2 cases that I cite here, both with United Soils. And again, that's the environmental thing we're getting back to. But here, to denounce and deter the plaintiff's conduct, $20,000 in damages. So on top of everything else, on top of having to pay your costs and the cost of their own lawyer, they also have to pay $20,000 in damages. And that, by the way, that $20,000 goes to you. It's damages to you. It's not like in the criminal situation, like it's a fine and it goes into the consolidated revenue. It goes to you. And the second United Soils, again, they thought that the case had been brought in bad faith and with malice and for an improper purpose, and another $20,000. So you can see how discouraging that's going to be for someone to bring an action for the purposes of trying just to shut you up and for doing it on a basis that's bad faith. Because someone can sue you and be wrong and it's still brought in good faith. Well, I thought that, in my view it was defamatory, but a judge found it wasn't defamatory. Okay, so that's not bad faith. But in both of these cases, it was said to be bad faith. And the test is there. Would a reasonable person informed of the facts conclude that a claim was initiated or pursued in bad faith or for an improper person? So you notice that that's an objective test. So we get back to there used to be an expression in the English law about the person that rode the Clapham omnibus. So riding a bus just an average person riding a bus in London, what would he or she think? In fact, it wasn't he or she back then, it was he. But anyway, so the objective test means that the judge can look at it and say, well, I think, not what a judge would think, but I think a normal person looking at this would say, gee, they didn't have much reason to sue you. You're the little guy, they're the big guy. You're pursuing these stories against them. They obviously wanted to shut you up. That's what it was about. And so they could find that it was in bad faith. These damages in terms of legal damages are not huge, $20,000. But when you put it together with everything else, and the fact that a judge has made this kind of finding against you, which of course would be public because all these decisions are public, it could amount to a real disincentive for someone to proceed. Although, you know, United Soils did it in 2017 and did it in 2018. So where do we go for here? Well, because we don't know what the Court of Appeal is doing, we don't really know. And on top of that, we've got the government maybe wanting to make a change. Although I have no reason to believe that, no one said that, but you wonder when the government's changing, what's going to change. BC had, as I said earlier, BC had SLAPP suit legislation. And when the government changed there, they repealed it. Which means that, by the way, if any cases are already going, you're fine. If a motion has already been brought, you're fine. But, you know, 2 years from now, if the legislation is not in place, obviously it's not going to be available to you. So while we are waiting for the Court of Appeal, there are many lower court cases that are working their way through the system. As I said, mainly dealing with comments on environmental and political issues, but there's no reason to restrict yourselves when you're considering all of this to those kinds of cases. The cases are now starting to go beyond defamation to include claims of breach of confidence, anywhere where the suppression of speech is at issue. Whether they're trying to do it by saying it's breach of confidence, or there is a defamation, or there is some copyright issue that's going to prevent you from publishing. Any of those things can come under the SLAPP suit legislation. So just because it's not defamation that's being claimed against you shouldn't mean that you just dismiss the thought of bringing a SLAPP suit motion. That's basically the overview of it. I didn't want to get into huge discussions about the legislation because frankly it's like angels on the head of a pin. When you look at some of the tests that the judges use in this, whether it's whether it was substantial or likely to, or whatever test they use, to be quite honest, because the judge is making the decision, and because these things can almost mean the same thing, they can squeeze it into whatever one of those categories they want. Not true with beyond a reasonable doubt, but if you're talking about, you know, balance of probabilities or strong likelihood, they'll use whatever wording they want to arrive at the decision that they think is just. So I regard a lot of that discussion about exactly what it is that you have to prove, whether it's not fleeting or frivolous, or reasonable grounds to believe, or based on credible and compelling evidence. All of those are words that the judge can make it apply or not apply. The one that I would, the good thing about reasonable grounds to believe is that there's a lot of jurisprudence on that. So that at least as an advocate, you can get up there and say, well, this is what the courts have said about reasonable grounds to believe. This is what you have to show. Credible and compelling evidence, that's the test on a publication ban, that the Crown or the person seeking the ban has to produce credible and compelling evidence. And the number of times we have been successful because they didn't put any evidence forward, let alone credible or compelling. They just got up and said, look, this is really going to be bad for the fair trial, blah, blah, blah. And we're able to say, no, they have to prove, they have to come up with credible and compelling evidence. So at least there is something that they have to put forward. We haven't had any of that in these cases, whether the courts are going to look at credible and compelling evidence the same way. We don't even know that that's a standard. It's just one of the standards that various lower courts have used. And the more recent cases suggesting the standard of balance of probabilities or something approaching that standard, well, How is that different from reasonable grounds to believe? I don't know. And I don't think that I don't think the courts know. I think that the Court of Appeal will, this is the kind of thing that we're expecting the Court of Appeal to rule on. What is the standard? What kind of situation should arise where the judge is going to not award you your higher range of damages? That kind of thing is what we're hoping for from the Court of Appeal. But it's, we just have to wait and see. And as I said, it's very unusual that we're waiting this long for a decision, which makes me think that the three members of that panel are somewhat troubled by some aspects of this, because they're all very, very good judges who are usually quite prompt in getting their decisions out.